So good afternoon to all of you who are joining us. Thank you very much for joining us this afternoon for our webinar. It's going to be very, very interesting. I'm Lior Porat, and I'm very proud to lead Gornitzky's Telecom and Media practice. During this short webinar, at least my part, I will try to address two main issues. The first one will be the general principles of the Israeli telecom licensing regime. And the second one will be the current lack of OTT regulation in Israel. And I will try to see what's going to happen in the future regarding those two items, and especially vis-a-vis the Israeli Ministry of Communication initiatives. We are very, very happy to have with us today Fritz-Ulli Pieper, partner at Wessing, Germany. And Fritz would later on share with us his insights regarding the European, German, and UK approach regarding those two interesting matters. And we are also very happy to have with us Dr. Yair Hakak. Yair is a Senior Deputy Director General of Strategy and Planning at the Israeli Ministry of Communication. And given that, Yair will share with us the regulator's point of view on the strategies and legal landscape in this rapidly changing field. Fritz and Yair, thank you in advance for participating, and we are all looking forward to hearing your insights. By the way, if anyone has any question, please use the Q&A chat, and we will be very happy to answer them at the end of the webinar, or just email us. You have our email addresses on the screen, and you can email us, and we will respond very, very shortly. So the first topic I want to touch is the current Israeli telecom and media licensing regulation. Very, very often the clients ask us, listen, I'm going to launch a new service or start a new activity in the telecom field, and I just want to make sure I don't need any license before I start. And this seems like a relatively simple question, and usually they expect the answer to be no. But in reality, looking at the Israeli telecom regulation, this allegedly simple question is not that simple and is actually pretty complicated. Let's start with a bird's eye view on the local regulation in Israel. Generally speaking, the Israeli telecom regulation is based on two main laws. The first one is the communication law, and the second one is the Wireless Telegraph Ordinance, which is a very old law. In addition, we obviously have a lot of regulations and sub-regulation and even former policies of the Ministry of Communication, sometimes very ancient ones. And also we have guidelines and decision of the ministry. But the main two laws are the ones I mentioned. And the provision of those two laws, which I just mentioned, are way, way behind the rapidly changing technologies, and not always, and I will even dare to say usually, are not that clear. So when you come to examine a specific advanced activity that a company wants to launch, it's often unclear whether it requires a license before launching the activity or not. And that is why we usually answer to the simple question that we need to look into it. It's not that simple. But you don't have to take my word for it. Looking at the website of the Ministry of Communication, you can see that the ministry says that the definition in the current laws in Israel, which were drafted in the 1980s mainly, are not appropriate for those for our times. Let's try to demonstrate this obstacle by looking at some of the basic licensing principles under the Israeli law. The first question is, who needs a license? So in Israel, under the communication law, it says that no person shall conduct telecommunication activities, and no person shall provide telecommunication services unless it obtains a license. As you can see, you can't start any activity which requires a license before you obtain a license. And in order for that, you need to figure out what is a telecommunication activity or telecommunication service. So, as you can see on the screen, it seems that we have pretty broad definitions, right? Let's have a closer look at the definition. Looking at the telecommunication definition, it's a very broad one, and it includes broadcasting, transfer, receptions of signs, signals, writing, visual form, sounds, or information, whether it's done by wire or wireless, optical. It covers almost anything. And accordingly, a telecommunication activity is defined as the operation, installation, construction, or maintenance of a telecommunication facility for the purpose of telecommunication, which is a very, very wide purpose. If I had more time, I could also show on the screen additional relevant definition, but we need to save time, so trust me when I say these are very, very broad definitions. But I think you've got the notion that these definitions are wide and basically capture almost every communication activity and service they want to do in Israel. Now let's have a look, or a similar look, at the second main law applicable in Israel, which is the Wireless Telegraph Ordinance. So who needs a license under the ordinance? Because you may not need the license under the law, but you may still need the license under the ordinance, so you have to pass those two obstacles. So according to the ordinance, similar to what is specified under the communication law, no person shall manufacture, maintain, operate, or establish a wireless device or wireless station without a license. And again, it depends on the definition of the terms wireless device and station, which you will not be surprised to see, again, that these are very, very broad definitions. A wireless device is almost any wireless device, any system, apparatus, device, installation, equipment, which uses radio frequency for wireless telegraph or is intended for the use, etc., etc., etc. And the wireless station, again, is a station that includes, it's like a round definition, it includes one or more wireless device, while wireless device is almost any wireless device you can think of. So we're basically in the same position as we were under the law. Almost every activity or service will be captured by those definitions, and therefore, usually the answer to a company asking us, do I need a license or not, would be yes. By the way, I doubt if that was the intention, the original intention of the ministry, but I think the actual result is pretty wide and pretty vague. In order to help us through this maze, I'll try to show on the screen to present a short diagram which will assist us in examining whether a specific or particular service or activity is regulated or not, by way of simple questions. First, we need to look into the question of the applicability of the licensing basic obligation, meaning if the specific service or activity is captured by the definition that we just described. If the answer is no, and as I said, this will be rarely the case, then we are basically off the hook and we don't need the license. But as I said, since the definitions are pretty vague, sometimes it's advisable to obtain a formal clearance from the regulator, and usually the regulator is the Ministry of Communication. There is in Israel a procedure that regulates the pre-ruling that the ministry operates, and we have been using it for a few years, and it's very practical. I wouldn't say easy, but practical, and in most cases it will be advisable. But in reality, in most of the cases, the definition would capture the contemplated service, so it would seem as if there is a need for a license. But still, we need to move on, because even if some activity or service requires a license in Israel, there are some exemptions which are set under the communication law, and some of the exemptions are set under different laws and regulations. For example, just recently, the ministry has refreshed the exemptions relating to wireless devices, the ministry issued a new regulation which tried to group together several exemptions which were set in separate laws and regulation, and even added new exemptions to the list. So you need to see if something needs a license, it may or may not have a relevant exemption. If you have an exemption, then again you're off the hook, and you can get a pre-ruling if you need. And if none of the exemptions applies, then you need to get a license. But that is not the end of the road. Some of the rules of interpretations are specified in the Ministries of Communication policy documents, and some are not even written. For example, the OTT service theoretically may fall within the definitions of the communication law, but the Ministry of Communication decided that it is not subject to licensing regulation. So it's very, very important to understand what is the ministry's policy and interpretation of the regulation before moving forward. If following this very long journey, the answer is that the license is required, it is still advisable to see what license is required, sometimes more than one, because as you can guess, different types of licenses leads to different types of filing and sometimes even different procedures. So it's very important to identify what kind of license is required. Let me give you an answer. A few years ago, one of our clients addressed us with a simple question. They were using, or they planned on using satellite phones, and they were almost sure that this is not regulated because this is a day-to-day activity, but they were careful enough to consult with us, and as it turned out, using satellite phones back then required a license, so we helped them and they got the license. And as I mentioned earlier, today, years later, using satellite phones was exempt, and now it does not require a license. I think we don't have time to elaborate more on this topic, but I would say one word about IoT, which is it's a very popular use of telecommunication. It raises very interesting questions regarding whether or not it's regulated and how. I hope that the ministry will address it. We know that foreign regulators started to address this question, and I hope that soon enough the ministry will address this item as well. One more note, I think that goes without saying that if you do need a license, and if a license is acquired, then acting without one may lead to significant sanctions, so it's not advisable. Now, so far it was the bad news. Now let's move forward for some good news. Last August, after years of attempts, the Israeli Ministry of Communication finally initiated a significant process of, I would say, deregulation, and published a new law memorandum, which became a bill just a few weeks ago. This bill is targeting on changing the format of the regulation regarding the provision of communication services. I think hopefully it will change it in a manner that will both reduce the bureaucratic burden and also reduce the barriers for entry into the Israeli market. I think the main item in the bill is that the licensing regime will be transformed from a licensing obligation today to operating under a general authorization that the ministry would specify, a bit similar to what is the trend is now in the European market. I will focus on three differences or main differences between the current license regime and the expected one. The first main difference is ex ante versus ex post regulation. Today, as I said, you cannot operate in Israel if you need a license without one, and you can only get a license following a pretty long and intense examination by the regulator. However, under the bill, all of this would be done, or almost all of this would be done exposed following the beginning of the operation, which can be done based on the general authorization that the ministry will publish. In other words, there will be a retrospective supervision and enforcement and not a prior one. Many services that today require a license would not require one anymore. However, it's notable that certain services of key importance will still continue to require a license, such as cellular infrastructure licenses. The second principle is the certainty. As I said today, I think the communication law is pretty vague, and the definition are broad and vague, and the bill tries, or at least aims, to simplify the definitions of the law in a way that it will be easier for all of us to understand who needs to get a license and who doesn't need a license, and will be able to rely upon the general authorizations. We should also remember that the bill is amending only a portion of the Israeli regulatory maze, and not all of it, at least the version today. So some of the uncertainty may remain. And the third and last principle is simplicity. As I said, the bill also aims to simplify the application process. Today, it's a very long and tough back and forth process until you get a license. If you get a license, and if the bill comes into effect, then you'll have a registration. And after you register with the ministry, there will be a very short waiting period, could estimate it by 2 weeks, and then there will be only a basic examination by the regulator before you can start and launch the service. The ministry estimates that the number of license holders will be reduced from about 150 to about only 30 license holders. This is a major change, and I hope it will come into force. I personally see it as a very positive move, a much needed one and a healthy one, forward by the Ministry of Communication. I hope that it will come into force, and that indeed the burden of the regulation will be significantly reduced. I do hope, in addition, that during the registration process, the ministry would look into the bill and try to make sure that the bill would cover all sorts of telecom and media activities, so we will not, get the regulation back in the back door. That's for the regulation regime. Now moving to the second interesting topic, the OTT broadcasting regulation, or would I say lack of regulation. We all know that the communication market is rapidly evolving, and the audiovisual market definitely is evolving very fast. And we have been experiencing changes, or material changes, even in the way content is being provided and consumed. Competition has been intensified. Local and global players entered into the OTT market, such as Netflix, Apple, and Amazon. But as I said, to date, no real regulatory adjustments were made to the current legislation over the years. And as I said earlier, the ministry does not see the communication law as applying to the OTT players and activities. So in practice, only the traditional players who provide a service via cable and satellite are subject to regulatory obligation. Some see that as a situation that creates an unbalanced and maybe even unfair playground. Now, the Israeli regulator is obviously aware of this situation, and several committees were appointed in order to try to look into the matter. However, the gap between the regulation and the technology seems to even expand, as none of the recommendations were ever implemented. Some of them were not even submitted. The last committee nominated by the ministry in last September is the Folkman Committee, headed by former Knesset member Roy Folkman, who was originally tasked with presenting its recommendation by December 2020. that didn't happen, obviously. And even today, we don't have any official recommendations yet. We may hear about them a bit later on from Yair Hakak, being a committee member, and this should be very, very interesting. By the way, earlier this week, Mr. Yoaz Hendel was reappointed as the Minister of Communication, and he already, I heard him over the radio saying that he will put some emphasis on promoting competition and reducing the regulation. And I can assume that his reappointment will also expedite the publication of the committee's recommendation, since he was the one that appointed the committee to begin with. Looking at the Folkman's committee mandate, in a nutshell, the mandate was to recommend on relevant regulatory principles, as I said, aiming on or focusing on reducing the regulatory burden. The committee was tasked with addressing various broadcasting matters, such as promoting local Israeli productions, limiting ownership of broadcasting providers, deciding what is the right structure for the regulator in order to regulate broadcasting, and also any additional issue that the committee sees fit. In other words, the committee was given with a rather broad mandate and I think the market had and still has high expectations from the committee. Later on, the committee published its call from proposal. As we all know, usually in committees, the calls for proposal at least implies what is the focus of the committee. And according to the call of the proposal of the Folkman Committee, their work was based on two assumptions. The first one is to be technologically indifferent, meaning to focus the regulation on the service, on activity, and not to base it upon the infrastructure or the technology that is being used by the operator. And the second assumption is targeting and simplifying the regulation to have a simple regulatory outline, taking into account the competition in Israel and the consumer's habit. So, in other words, the committee believes that the effective way for the regulator to achieve its goal in the digital age is by simple, smart, and convenient regulation. This obviously is very, very desired, but the real question is how will this be done in practice? And as I said, we don't have the recommendation yet. I think that maybe the most interesting question vis-a-vis the committee is whether or not the committee intends to recommend to apply the Israeli regulation on the OTT players in general, and specifically on the OTT international or global players which have entered the market so far. According to the media, there have been some disagreement between the different members of the committee regarding this issue. Some of them said that the new regulation may place high entry barriers for new entrants and may also even lead service providers such as Disney to reconsider their entry into the Israeli market. I'm not that sure that is the case, but at least that is probably an opinion that was expressed. And if indeed the global players would not enter the market or will get out of the market, they say that it may, at the end of the road, harm the Israeli consumer through weak competition and maybe higher prices. Still, at least in the media, it was reported the committee is considering some sort of recommendation of putting some portion of the global players' income in local production to incentivize the local producers and to help the local production here in Israel. I think that in the media I also read that Netflix was quoted as saying that the recommendation, if indeed would be in place, is concerning and unrealistic. And I think we should be careful from setting an example which will be different from the rest of the world. It's not that we can't do it, but we should do it carefully. In any way, demonstrate that the recommendation potential impact on the global OTT players is maybe a significant one, and also the impact of the recommendation on the traditional players who are struggling with the local regulation that doesn't apply to all players also important. I personally think that the global players, I wouldn't say regardless of regulation, but even without regulation, will invest some portion of their income in the local industry because they have the need to they want to stay attractive to the local consumer. I think they value the Israeli market. For example, looking at Netflix, which is maybe the oldest global player here in Israel. It acquired several Israeli series such as Fauda and Ashoter Atov, two transactions that we were involved in. And that was done before any committee recommended anything. So I think that the regulation may be in place, but I'm not sure it's that essential. It should, however, create a balanced playground for the players, focusing mainly on incentives and not on sanctions. That is it. Thank you very much for listening. I'm very, very happy to pass the ball to Fritz, who will guide us through the United Kingdom, German, and the European angles. And as I said, you can, if you have any question, please do it via the Q&A or email us later on, and we will answer you. Fritz, the ball is yours.
Many thanks, Lior, and thanks for the overview. Can you stop sharing your screen, as Zoom tells me I can't share mine? Okay, there it is. Thanks. It was very interesting to hear what the current state of the licensing regime is, and also what the future scheme, let's put it this way, will look like, because it reminded me very much of the not only of the EU but also of other licensing regimes that I've come across. So let me just quickly share my screen and guide you through that very short presentation that I've prepared. Can you see it in full screen? Just quickly checking. Okay, thank you. So first of all, this is a cooperation between Gornitzky and the Wessing Israel desk, which is not only based here in Germany, but also heavily based in the UK with Nathan Krepivensky. And we also want to have actually one of my UK colleagues, Angus Finnegan, on board. But as he's on honeymoon this week, he's excused. But still, this is why I'll try to implement a little bit the UK overview also in my presentation, even though it's not my main focus. But it's similar to the EU and the German regulation. So I'll give some insight into that, or try to give an insight into that as well. Second thing I wanted to point out is that's what I was just introducing everything with, Lior, when I said it reminds me so much of the European framework, what you just said. Not only that, I just recently consulted with an M&A project where the target was a big IoT M2M solutions provider. And they were involved in many countries all over the world. They didn't, let's say, care too much. They did care, but not too much about telecommunications law and licensing regimes, which is why we had to conduct an international focused approach and see in what countries they are active and whether they need licensing and registration. And the 8 main countries were spread all over the world, and it was the exact same picture that you basically painted. Either it was regulated by a license, or there was no license regime at all, so you could just start, or it was ex post regulation. It's very, very mixed. And you will see that this is the case for Europe and UK and Germany as well. And it's shifting a lot. A lot of regulatory proceedings, legal statutory proceedings are going on. And I'll just try to give a brief overview of that. So actually, I'll try to summarize the 2 points, main points of our topic today, licensing regime and OTT services today, which are in Europe based and regulated in statutory provisions. They are mainly regulated in European directives stemming from the EU, the Commission, the Parliament, which means they lay down a groundwork for the regulatory provisions, and the countries, they have to implement them into national local laws. And this has happened in German law, and it has also happened in UK law, but as you're all aware that now that UK is not part of the EU anymore, this derivation of national legislation from EU directives is no longer necessary for the UK. In any case, I'll give you a bit more background of the regulatory overview of the regulatory background. So the regulatory framework in Europe currently exists, or rather until very recently existed, in 6 directives and 1 decision, all tailored at specific topics, like the Framework Directive, which had very broad requirements in it that countries needed to implement, for example, when it came to notification, licensing, but rather very abstract. It didn't say you need to license, but it rather said you need to have measures in place where you conduct as a national state and the regulatory authority, where you conduct measures to keep an overview of the market, be it by licensing or other measures, for example. So it's very broad, very abstract. And for specific topics in the light of the technical developments, there were further directives. For example, when it comes to accessing of lines of monopolistic market participants, or when it comes to regulating universal services, who has to provide those. So it's just like a puzzle you had to put together of all those directives and then derive for the national law the local provisions. That was the case for Germany and the UK very similarly. The thing with directives is they are not directly applicable. So the countries, they do have some flexibility in implementing them in national law. So this means that not in all European countries you needed a licensing or a notification requirement, for example. But what happened very recently, in 2018, the EU came up with a completely revised approach of the telecommunication regulatory regime for Europe, which was called and is called the European Electronic Communications Code. Its goal was mainly to implement all prior directives or topically focused directives into one big and concise regulatory framework. So that was the case in 2018. It became valid in 2018, and the countries all over the EU had time until end of 2020 to implement it into national law. It has now been implemented into German law with a little, we were a little late. The new law will come into play in December largely. But in the meantime, as you know, there was also Brexit. So UK was still on board when it came to comprising the new directive, the EECC, but they are not obliged to implement the framework as of now into national law. In any case, as the framework already based on EU framework legislation and was already transferred into UK law, and the UK law thus has quite a similar structure, it's expected that the national law in the UK will also be very similar to the current directive and to the proceedings and structures that were there already. So specifically looking at the licensing regime deriving from those regulations and directives, it's very important to understand a little bit about the history of licensing and telecommunications regulation, particularly, for example, here in Germany. We had different phases of market opening, let's put it this way, of market developments. Initially, in very early times, there was the Federal Post Office. It was a federal public authority being responsible for telecommunications, lines, regulations, etc. So it was a state monopolistic activity. And this was at some point it was loosened also by the German constitution, where it said it should become private now. And this is when the first phase of market opening started. But as you can imagine, it took a while, to get used to this very new paradigm shift. So the initial step was to have a strict and preventive access control to this new, completely privatized market in place. And that was the case also for a license obligation. So the operation of transmission paths and the operation of voice telephony services, they required a respective license from the regulatory authority, the Federal Network Agency. But as you can already tell, these descriptions of the technical services, they're rather outdated and very old. So once the market started to function and became more liberal and many more players entered the market with technology evolving rapidly, it was decided that this even new regime, the first phase of the market opening regime, wasn't necessary and helpful anymore. So there was a big revision, also due to the European directives that we've seen on the slide before. And for example, in Germany, the new implementation led to a completely revised German Telecommunications Act. The system change from market opening and licensing to a more flexible, more open market was an essential element of the directive package that we've seen. The EU wanted to make the markets more open, more flexible, and the markets became more mature. Individual control of the access by federal agencies and controlling the regime wasn't longer necessary. So also the licensing regime switched and went, at least in Germany, from licensing to a notification requirement, which is actually significantly different, because at the time it said anyone who commercially operates public telecommunication networks or commercially provides publicly accessible telecommunication services shall notify the Federal Network Agency. I think we can see here slightly comparable to the Israel regime. The telecommunication services, for example, it's also a very, very broad term, and the discussion what's really to be understood as telecommunication service, especially, it's always hard to do. It's a gray area sometimes, and those are always questions that arise, because when you're a telecommunication service provider, you'll be regulated fully by the German Telecommunications Act and fully fall under the regulatory framework. So that's the situation as of now. In the UK, it's even more flexible. It's just that you have like a general allowance to provide the services, but you will have to double check whether you are subject to the regulation and then apply it. But there is no licensing or notification obligation in that. So it's even a bit more open, one could say. Specifically looking at OTT services, I think we should note duly that when we talk about OTT services in the EU, and especially also in Germany, and to my understanding also in the UK, we're rather looking at OTT telecommunication, meaning communication services rather than broadcasting services. So there is a distinct distinction between those services. And especially the regulation of OTT communication services has caused considerable legal uncertainty in the last years, because there the question when is actually something a telecommunication service and falls under the telecommunication regime, it was like the main question that always arose when you had OTT services in mind. And with the new regulatory regime, it has undergone groundbreaking changes, actually, which I would like to discuss and present a little bit now. So, as we've already seen, the legal definition of telecommunication services, we have those if there's a service that's consisting in wholly or having as their principal feature the conveyance of signals. So, if any service had the conveyance of signals as their principal or whole feature, then this would have been defined as a telecommunication services. And then this OTT service would also have been deemed a telecommunication services. The problem with OTT services is actually, in most of the cases, that they have both a signal conveyance part and a content component. For example, Skype or WhatsApp, they have signal transmission. Without it, it wouldn't work. But they also transfer the content of the messages, for example. So this is why that was highly argued and highly, let's say, an area where there was a lot of legal uncertainty. And we had actually a few legislatory proceedings in front of courts. There was this widely observed case targeting Google Mail, where the German regulator said Google Mail, as a mere email provider, also has to somehow make sure that the signal conveyance of the data packets is undertaken and transferred correctly, otherwise the service wouldn't work. This is why they measured to the service a signal conveyance part. This is why they said you are telecommunication service, Gmail, and you need to notify your services at the Federal Networking Agency. The thing is, falling under the telecommunications law regime, the notification is, let's say, the least problem, but you have to take into account many more obligations like public security obligations, lawful intercept, maybe it depends on the service, but all those things that really hurt effort-wise and monetary-wise that you really don't want to have to be regulated by. So this is why Google went to court and said, we are not a telecommunication service, we are a content provider. This proceeding went on over a few years actually and led to the European Court of Justice finally taking the decision that Google Mail is not telecommunication service provider because they don't have control over the lines and over the signal conveyance. So the main focus was on the content side. Whereas with Skype Out, there was a similar proceeding from Microsoft. And yeah, there you can clearly see that depends on the technical setup and structure. For Skype Out, they decided Skype Out is actually telecommunication services because it has as a principal feature conveyance of signals. So actually two similar services, but with a completely different regulatory regime after those court cases. So these legal uncertain parts, it is hoped that they are now in the past because based on the new structure from the European Electronic Communications Code in the EU and the national domestic regimes, it is hoped that this will remain in the past now because the definition for telecommunication services has fundamentally changed. It has become more specific, and it now entails a selection of such services between internet access services, so-called interpersonal telecommunication services, and as a third part, services consisting wholly or mainly in signal transmission, which is basically the same as the prior definition in the old part. The interesting part here is that due to the legal uncertainty regarding OTT services, the lawmaker specifically included interpersonal telecommunication services in the definition of what a telecommunication service is. And this is legally defined by a service enabling direct interpersonal and interactive exchange of information over telecommunication networks between a finite number of persons, and the recipients being determined by the person who initiates or participates in a telecommunication. So when I call someone via Skype Out and want to have this communication services, then I initiate the process. I or my provider uses telecommunication networks to proceed with a signal conveyance. That's an interpersonal communication service, and that has now actively been decided they have to be seen as telecommunication services. The regulator made the active choice to have them regulated under the telecommunications regulatory regime. But they also made a little exemption for ancillary functions inextricably linked to another service. We consulted with a client who provides in the gaming sector hardware, so gaming consoles, and for their games they implemented network functionalities and a chat functionality, and we argued that the communication part within this in network gaming was just an ancillary function, so the chat part of the whole console wouldn't be deemed a telecommunication service. So this is actually what this exemption here is for. Interpersonal communication services are again also divided between number-based and number-independent interpersonal telecommunication services. Number-based being the ones where you get assigned a number of a number frequency range that an operator provides. Ultimately, this leads to the following regulatory requirements. You will have to not apply, but make a procedure towards regulatory authorities, Federal Network Agency in Germany, for example, and make a notification. It's rather straightforward. They have documents already in place that you just have to fill out. You have to become a bit technical about what services you provide. For telecommunication services other than number-independent interpersonal telecommunication services. So if you're a number-independent telecommunication service, then you do not need a notification. So it's kind of tricky to keep track of when you are subject to notification. But in my view, it's a well thought through process when someone really needs to notify, and when that's not the case, because for number independent services, the numbering is not in place and the regulatory need isn't there so much. So the notification can actually be applied quite reasonable. You have to keep in mind that whoever you would fall under, like whenever you are either a telecommunication service, number-based or independent, interpersonal telecommunication service or the service provider, you always have to keep in mind those three definitions, because the obligations from the new regime, they vary even heavily, partly, depending on what kind of service provider you are. For example, if you're an operator, you usually subject to the widest regulation, of course. But if you're a service provider, you have to double check what obligations apply. There are, for example, exclusions for machine-to-machine providers that they would not implement. They have to implement specific obligations, for example. And this relates to a whole variety of regulatory duties. For example, customer protection, structuring your contracts with customers in a specific way, frequency allocations, rights of way, public security is regularly always the biggest part where you take a look at, because it's always very costly. It takes a lot of effort to comply with the regulations, having security, technical, organizational measures in place, providing security concept to the regulator. And when not abiding with these duties, you may even face administrative procedures and even up to fines imposed by the regulator. So, in short, at first at least complex structure, but in my view well thought through and adapted to the new technical requirements in Europe, Germany, and the UK. And happy to have provided that overview. If there are any questions, we collect them and I'll be happy to answer them afterwards. So based on this, I'm now very keen to find out, because it seems that Europe and Germany, UK have already made steps towards a revision of the telecommunication legal regime. So this is why I'm now very keen to know how this will come about in Israel by Yair. Thank you.
Okay, thank you very much, Fritz. Just 1 second while I get my slides up. Okay. Okay, do we see a slideshow? Excellent. So thank you very much to Lior and to Fritz, and for letting me have the last word. So my name is Yair Chakak. I'm the Deputy Director General for Strategy and Planning of the Ministry of Communications. And I'm going to take you through a little bit of our thought process on both of the initiatives that we've been talking about today. The first one is the new licensing / general authorization regime bill, which is tabled in the Knesset. And the second is a little bit about OTT services. So I have to start with a short disclaimer. I'm not an attorney, I'm an economist by training. And of course, the contents of this presentation are informational. It is recommended to seek the assistance of qualified local counsel before carrying out any activity that might require licensing in Israel. Please don't take this as a specific endorsement of our host today, but please do seek professional counsel. That's helpful. Okay, so it's very important when we talk about what we're doing now to see sort of in terms of path dependence where we've come from. So like in most European countries, communications were carried out by the state, by the General Post Office until 1984, at which point things were spun off into a publicly owned corporation called Wessing, which was granted a statutory monopoly on all issues of telecommunications. In other words, Wessing's original license was 1 page long, and it basically gave them a statutory monopoly on any forms of communication. Which, if you'll refer back to Lior's presentation about the communications law, you know that communications in the communications law is defined very, very widely. The monopoly was canceled in the 1990s and competition began in various sectors, starting with international long distance, which today we tend to think about as being sort of a small niche market, but at the time was 20% of the revenues from communications. And eventually, after going through mobile communications and other things, gradually spread to what we would consider sort of the hardcore of the natural monopoly in telecommunications, which is fixed communications. That was liberalized in 2001 with the entrance of Telecom, which had been the cable company, into the communications sector. Today, the sector is fully liberalized. There's free entry into all market segments. And another thing that I should say before we get to what we're doing now is that in 2015, Israel adopted a European-style wholesale market in fixed communications elements, which had not been the case if in Europe wholesale markets begin more or less with a decision by Ofcom in 1996. In Israel, we came to wholesale markets relatively late in the development of this sector. So the licensing regime, you know, somebody once told me that it's absolutely miraculous that we managed to have a liberalized communication sector de facto in the context of the existing communications law. But the licensing regime remains in effect. It has been amended somewhat, but remains in effect more or less since the 1990s. And as Lior pointed out, but this is an important thing to stress, the communications law does hew to a paradigm of licensing of this sort of chain of communication services, which are provided over communications network, which involve transmissions, communication signals, which, by the way, if you're into these sort of things, you can trace this back to the Post Office Act of 1921 in the UK, which was basically transcribed into the British Mandatory Government for Palestine's 1929 Post Office Ordinance, for those of you who enjoy such things. But the issue is that this is not a prescriptive requirement. It's a descriptive requirement. In other words, it was assumed by the drafters of the law that this is how communications work. And as Lior correctly pointed out, it's a very wide remit, and it brings almost all services at all network levels into the world of licensing. So in short, I would say that the licensing system, the existing licensing system in Israel, is designed to serve a monopolistic sector, and it hasn't kept pace with the liberalization of the sector. So the new law, which was tabled, which has passed the first reading in the Knesset and now goes to committee, and now with the new government, hopefully we'll have full functioning committees in the Knesset, and it'll bring a much needed update to the basic parameters of the communications law and bring it into conformity with the paradigms, with the more modern paradigms that we know of today. And as part of the law, we intend to move to a general authorization regime, which is similar to what is in the code. It's what used to be, for those who sort of know the European legislation, it's the things that used to be in the authorization directive and are now part of the code, which sets out that general authorization should be the default way of authorizing communication services. And specific licenses are reserved for cases either of specific allocation of resources, and the classic example of that would be frequencies, or a specific public interest that require the ministry to have a specific licensing relationship with a specific kind of operator. So the process envisioned by the amendment obviously will take some time to implement. One can't move from a licensing regime to a general authorization regime overnight. But the hope is, the hope is that undertakings wishing to provide services will have, first of all, a clear idea of whether their service is covered, and if so, whether they need to register under the general authorization. And again, accepting those cases in which a specific license will be necessary, registration will generally suffice to provide services. Obviously, registration implies a commitment to adhere to the relevant rules and regulations for a service. So, for example, if an undertaking wanted to provide voice services, they would have to undertake to adhere to the rules about number portability and all sorts of things like that. But that would generally suffice to provide services. So that basically means, if I'll be a little bit theoretical about it, no barrier, no market entry test, and full entry into the market. And in addition, and this is something that Fritz pointed out, and we learned a lot of this from our European counterparts. In fact, we had some very interesting discussions with the Bundesnetzagentur, with the German Federal Network Agency, specifically about cases in which undertakings were essentially forced to register, despite the fact that there didn't seem to be much public interest in that registration, and we are trying to avoid those things. And therefore, one of the things that is in the law as it is tabled in the Knesset now is a very, very clear line between what requires general authorization and what does not. While we did, to a certain extent, consider the dichotomy made by our European colleagues between numbering-based and non-numbering-based services, there's a certain advantage in being late to the game. And that is that we can learn from other people's experience. And so if you look in our tabled law now, you'll see that the distinction between what needs to be registered under the general authorization, what does not, is basically the control of network elements, which would imply that OTT services are entirely out of scope. So that's something that I think that the fact that Israel has waited and is one of the last sort of developed countries to do this kind of change and to change to a more functional approach to licensing and to the communications sector in general is actually to our benefit, because it allows us really to learn from other people's experience and to tailor our new legislation to really the state of the art in both in terms of networks and in terms of regulation. So what are the advantages? The advantages, the first one is obvious, it's a lower barrier to entry. Now again, if you look at the European Communications Code, then one of its aims is to allow for inter-country competition, to allow undertakings to see a regulatory framework everywhere inside the EU that won't have an extra barrier for undertakings from one member state to operate in another. That's not necessarily relevant for Israel, but we do want to lower the barriers to entry. We want to level the playing field. The problem with the licensing regime is that licenses change over time. General authorization applies to everyone all the time. And if it is amended, that amendment is automatically applied to everyone. And if, as opposed to a license in which a license is specific to an undertaking and therefore amendments to licenses only apply to that specific license holder. Which means everything from, Israel, Hebrew is a language with male and female pronouns. So it means even in the very banal sense that we'd have to do every licensing amendment twice because one company's license was written in the male pronoun and one in the female. That's obviously not a real problem, but sometimes there are problems that are the result of the fact that licenses have changed over the years, and what is in one license isn't necessarily in another license. And that obviously leads to all sorts of claims about enforcement that may not be identical to all players, and that is unfair. So that's something that the general authorization solves as well. It reduces the bureaucracy involved in licenses, the granting and extending of licenses. I'm talking about the technical aspects of it, which are really administration and not actual regulation, and those will hopefully go away. And from a regular's point of view, and I speak now as somebody who sort of has to see the holistic approach inside the ministry, it frees up many of the ministry's resources to do actual targeted regulation in the areas in which we think that there might be risk to the public interest, market power, sensitive infrastructure, etc., and not to do things across the board when they're not necessary. So in a hopefully seamless transition now, I'll talk a little bit about audiovisual services. Audiovisual services are somewhat different, right? Because everything I've described until now, it basically comes from the principles of competition policy or economic policy, right? If you've noticed, I talked a lot about leveling the playing field and barriers to entry and all these kinds of things, and these are things that we sort of see coming to us from economic markets. This is something that in many cases, you know, as many of you know, in Europe, there have been some cases in which the telecommunications regulator has been merged back into the competition authority. In Spain and in Holland, I believe that they've been merged back into the competition authority. And so the principles are very similar. Audiovisual services, and we'll get into in a minute whether there's a difference between traditional services and OTT services, but the regulation on audiovisual services come both from the economic aspect, but also from other aspects, from social, cultural, educational aspects. And so obviously the educational aspect is very obvious, right? There's some thinking of television as something that sets up people's consciousness, that is not it's a product that isn't agnostic in terms of values, and that therefore it is proper that there be some regulation on what's on TV, so to speak. And again, you can take this in various directions. The Americans have taken it in one specific direction, but there are also cultural issues here, right? Israel, we'll get to this, but Israel is a small country with a unique national language with only a handful of millions of speakers around the world. So that's the first thing that I think it's important to say. And this is behind a lot of I think of the uncertainty and the lack of understanding about broadcasting or OTT broadcasting or OTT audiovisual regulation, is that it really comes from a different place. At the same time, television services or audiovisual services, and I won't now necessarily get into the distinctions in for example, in the European directive between on-demand services and linear services and video VSPs, video sharing platforms. But the competition between the traditional multi-channel TV and the OTT services are becoming increasingly obvious. And therefore, and this is not true just in Israel, the regulatory paradigm that differentiates between them is also being increasingly challenged, because around the world, traditional operators are coming to the regulator and saying, listen, we can't deal with such a misaligned, not level playing field. It's not viable. So the Israeli paradigm, which was in force for about 30 years, since the beginning of sort of commercial broadcasting here in the 90s, it's based on, first of all, a very strong distinction between the broadcast television, the free on-air television, and the multi-channel TV services. A very strict dichotomy between them, and all sorts of rules about your inability to hold both kind of operators. As I said, the distinction is becoming increasingly less viable, and the Folkman Committee was basically impaneled to recommend a new paradigm. And I'm not giving anything away when I say, again, that this is the main challenge of the committee. The question is, and this is, I think, the crux of the issue, is to what extent we can have a liberalized sector, but still have a level of local high-quality content which is satisfactory, where one could use the term market failure in a wide sense to describe this kind of content. So this is really the crux of the issue, if you want to boil it down. So let's talk for a minute about this issue of high quality content. And the one thing that I always am very careful to do whenever I talk about this is to say that on the national level and on the regulatory level, right, Israel is committed to the open multi-stakeholder approach. We're a small open economy. It's been very good for competitiveness in Israel, and we want to maintain that. And this is something that I think bears saying whenever regulators talk about the challenge of OTT services. I think all of us, and regulators and regulated entities and other stakeholders, have to understand that these are good problems to have. OTT services have solved many, many competitive problems in many, many industries, and have basically opened up, in our case, the Israeli consumer to service providers that they wouldn't have dreamed of having access to before. And yes, there is some work to be done, but this is a good thing, and that bears remembering. As I said, on the other hand, Israel has a unique local language which has no export market, unlike English or French to a certain extent, which content in those languages has a large export market. So as Lior said, the best that an Israeli content creator can hope for is to sell what we call their format, their idea, but not the finished content because it's in Hebrew. And I also do have to say that that the fact that the regulator wants there to be local high-quality content is increasingly in line with best practices around the world. We are seeing more and more regulators, or more and more countries, take that approach. You know, the European directives on content allow for member states to set up these mechanisms, and some European member states have done so. So that's really all I have to say. As I said, I can't speak specifically to the recommendations of the Folkman Committee because they haven't been tabled yet. But as we say, you know, watch this space for developments. So we hope to share that with you fairly shortly. And again, thank you very much to our host today, and happy to take any questions in whatever format Lior would like. So.
Thank you very much, both Fritz and Yair. In the Q&A, I think there are two questions. One of them may be Yair, maybe you can answer, and the second, I think it's for Fritz. So someone asked about, let's start with Fritz. Fritz, can you please say a few words about the IoT licensing regime in the EU?
Happy to do so. So I would say that when we look at the new regime, where there's still some kind of necessity to engage with the regulator, not by licensing, but rather with notification. This would also apply to IoT services when they fall under the definition of a telecommunication service. So as I've mentioned, the definition for a telecommunication service is divided in three parts, and machine-to-machine communication, which I understand would be a primary use case for Internet of Things. There would be the question whether such machine-to-machine communication would constitute an interpersonal communication service. That's regularly not the case. That's also in the reasoning of the new law for Germany. But as we still have the conveyance of signal part, this may be a service which is subject to the licensing, or rather the notification regime in the EU under the European Communications Code. We've recently advised an IoT connectivity service provider who is basically a mobile virtual network operator, providing connectivity via SIM cards from operators, providing a core network for allocation of connectivity services and a few services around those connectivity services, so core software, etc. So the services they provided was purely focused on IoT machine-to-machine communication, providing entities with specific communication and connectivity services, and enabling the customers to administer and use and steer the machines respectively. And for Germany, and also, for Germany at least, it was clarified in one of our conclusions that this would count as telecommunication service provision, which would then be subject to the EU, German and the EU regime, for example. So I think there are quite a few use cases in the IoT sphere which would be subject to the respective regulation. I hope that answers the question.
Yeah, thanks. And the second question, Yair, I hope it's for you, not for me, because the question is, when do you think the Folkman Committee recommendation will become public?
It's a good question. I remind whoever asked the question, who I see is anonymous, that the new minister has been in his position for exactly 2 days. So yes, he is the new old minister, so he has some background, but I think it may take a few weeks. I hope we're not talking about more than a month or two, but again, I don't want to say anything definitive.
For the submission, or you mean for the submission of the publication?
As far as I understand, when it is submitted to the minister, it will be published.
Okay, great, thanks. I don't see any other questions, so whoever has additional questions, please email it to either any member of the panel, whoever you want to address the question to, and I'll take this opportunity to thank you again, Fritz from Wessing and Yair from the ministry. I think it was very, for me, interesting to see the Israeli, UK, German, European, and the regulator addressing those two items. And indeed, there's a lot to wait for the recommendations. Expectation, as I said, expectation was very high, and I hope we would not be disappointed. That's life. At least in the sense that this is, I don't know, one number of committees. Many committees failed to reach the finish line, and this committee seems to reach it. So hopefully we'll have some news. Thank you all to whoever participated, and see you in the next webinar.